Hello students, and welcome to the next session of company law. In the last session we had discussed about various provisions relating to the inspection, inquiry and investigation. The inspection, inquiry, investigation can be done by a registrar of the company, inspectors, or there can be SFIO. All those provisions we have studied. Now we will proceed further and we'll try to understand the provisions relating to the prevention of operation and mismanagement. Prevention of operation and mismanagement. Prevention of operation and mismanagement. So in short, we will try to understand majority versus minority disputes. In the company setup of business, generally the decisions are taken by the majority of the shareholders or directors, as the case may be in the case of the board of directors meeting. And generally it is seen that the courts are not supposed to intervene into the decision making powers which are conferred upon the shareholders or directors by the lawmakers in the Companies Act 2013. So when the decision is taken by the majority, it should be honored properly. But it should not happen that in the hands of a majority of the shareholders, the minority shareholders' rights are not protected and they are being oppressed. And that is the reason there are some provisions relating to the prevention of operation and mismanagement. So let's take an example where there are 5 shareholders, A, B, C, D and E. Out of these 5 shareholders, 3 shareholders are holding more than 80% of the shares in the company, and whenever these 3 shareholders will come, they can pass any resolution on behalf of the company, and they can take the decision without even consulting to the minority shareholders. So in such scenario, it becomes very important to protect the interest of the minority shareholders as well. So in a company setup of business, this problem may occur, and that is the reason in the Companies Act 2013 there are some provisions made with regards to the prevention of operation and mismanagement. There is one famous case law which talks about the rule of majority. The case law is Foss versus Harbottle. Foss versus Harbottle. This is the case law of 1853. So this particular case law talks about the rule of majority. The rule of majority. We will try to understand what exactly was happened in this particular case law. So the corporate law works on the principle of democracy. It's a democratic form of the setup, and it becomes more vulnerable because it is reckoned with the number of shares. So in this case law, which was considered as one of the landmark judgment in the history of company law. So it states that ones who hold majority of the shares rule the company. So what does it say? Ones who hold majority of the shares rule the company. So in this particular Foss versus Harbottle, the judgment was held that if the majority shareholders have made the decisions to take or not to take the certain action, it shall be respected, it shall be honored. and the courts are not supposed to, or courts are not expected to ordinarily intervene to protect the minority interests affected by the resolution. So we'll try to understand what exactly was happened in this particular Foss versus Harbottle. There were two shareholders who took an action against the promoters and the directors of the company for taking some decisions, and their allegation was the directors or the promoters of the company had misapplied the company assets and had improperly mortgaged the company's property. Now, after filing this particular petition, the court rejected the two shareholders petition, and court stated that the breach of duties of the directors was a wrong done to the company. It was the wrong done towards the company and not towards the shareholders of the company, or two individual shareholders of the company. And the proper plaintiff would have been the company in this particular case and not to the two shareholders. And on the basis of that, the court rejected the application petition made by these two shareholders, the allegation made by these two shareholders. So two major rules or the principles of the company law, the court took the support of. The first one is, the first one was, court held that a company is a separate legal entity different from its shareholders, and the courts will not interfere with the internal management of companies acting within powers. So court was of the opinion that a company is a separate legal entity which is different from its shareholders, and in this particular case company would have been the proper plaintiff to file the petition. But the petition was filed by the two shareholders, and that is the reason it was rejected. The locus standi was not, the court was not convinced with the locus standi, or the petition filed by the two shareholders, and the courts may not interfere with the internal management of the companies, where the law has given wide powers to the shareholders and director to act upon it. But the Indian, when it comes to the Indian law, Indian law protects the interest of the minority shareholders as well, and there are some provisions where the minority shareholders interests can be protected. So there can be some exceptions like ultra vires acts or any kind of illegal acts which are committed by the company, then courts will definitely intervene. Then where the fraud has been committed, or where the transactions requiring special majorities and the resolutions have been passed by the only ordinary resolutions, courts will intervene. So there are various exceptions we can say under Indian law. Exceptions to the rule of Foss versus Harbottle under Indian law. So which are those particular rules where ultra vires or illegal acts are committed, transactions requiring special majorities and the fraud committed on minority. Okay, so ultra vires or illegal acts and where the transaction requiring special majority or fraud committed on the minority. In such cases, the Indian law will intervene and will give the protection to the minority shareholders. So now we are going to understand exactly what is meant by operation, what is meant by mismanagement, and the provisions regarding it. I hope this concept is very clear to you. First versus her bottle. Now we are going to talk about operation and mismanagement. Operation and mismanagement. Now these terms are not defined under the Companies Act 2013. But what does it mean by operation? Operation is something is an act, okay, which is oppressive in nature, which is prejudicial to the interest of the shareholders, which is going against the interest of the shareholders. You can say when we take the literal meaning or literal dictionary meaning of the word operation, will understand it is harsh or authoritarian, okay, attitude, approach of the majority shareholders towards the minority shareholder. That may be the meaning of the operation. What about the mismanagement? If the decisions are not taken in the good spirit, okay, or as per the articles or the memorandum of association of the company, if the powers which are conferred on the directors going beyond that, if the decisions are being taken, if there are some related party transaction provisions, okay, which are being violated, if certain other acts, okay, which are not, okay, under the powers, within the ambit of the powers, in such scenarios, okay, or if the appointment is made, okay, appointment of the senior management is made without taking into consideration the minority shareholders as required under the law or the rules or the provisions under the articles of association. So in all such cases, okay, it may be termed as the mismanagement. Now operation and mismanagement, these provisions are given, okay, under section 241. So we are going to talk about sections 241 to section 245. So to constitute an operation, the person concerned with the management of the company's affairs must in connection thereof be guilty of fraud, okay, or misconduct towards the members. It does not include mere domestic dispute between the directors and the shareholders. So in the capacity of the shareholder, he should have faced certain, or he should have suffered certain problems. Then only the act will constitute as an operation. So Act defines operation as Operation and Mismanagement Act. Under section 241, so we'll start with section 241 first, and then we'll move on to understand the other sections. as well. Okay, so section 241 says that application to tribunal for relief in certain cases of operation. Application to tribunal for relief in cases of operation. So under section 241 we are going to study 241, which says that any member of the company who complains that, so there are the rights of the members given. Okay, then the central government suo motu can apply to the tribunal for operation and mismanagement. So these sections provides the circumstances under which an application can be made by the tribunal or by the member of the company to the tribunal by member of the central government. Okay, so first we'll talk about rights right to apply by member. Right to apply by member in case affairs of the company have been or are being conducted in the manner prejudicial to public interest or oppressive to members. Due to material change it is likely that the affairs of the company will be conducted in the manner the manner prejudicial to the interest of members, prejudicial to the interest of members. Okay, so in the nutshell I have written these two particular points where the right will be given to the member to apply, okay, to the tribunal about this petition under operation and mismanagement. So when the shareholder is of the view that, okay, the affairs of the company have been or been conducted, so it talks about the past tense also, have been, it has been, okay, since past events, okay, have been conducted or being conducted, mean in the present moment also, okay, there are some things which are going on which are in the manner prejudicial to the public interest or oppressive to the members' interests, or due to some material change. Okay, now the material change not being the change brought about by the by or in the interest of any creditors including debenture holder or class of shareholders of the company has taken place in the management or control of the company, whether by an alteration in the board of directors, manager, in the ownership of the company. Okay, so in such a cases, okay, it is likely that the affairs of the company will be conducted in the manner again prejudicial to the interest of the members. So in such cases, okay, the petition can be filed by, okay, the member of the company. So section 241(1) talks about, it addresses the complaints on the conducts of the company's affairs which could be prejudicial to the public interest and prejudicial or oppressive to the members of the company. So this particular provision gives a right to the members to approach the tribunal, to move to the tribunal not only on the complaints of operation. So first point talks about the operation, but also if there is any kind of material change happening which will go against the interest of the minority shareholder, then also they can go and approach the tribunal. And the second part, okay, which talks about right of CG to apply, right of CG to apply tribunal. If it is of the opinion that prejudicial to public interest, save apply. Okay, so even the CG has been empowered to do so if it is in his opinion, okay, if the CG is of the opinion that affairs of the company are being conducted in the manner prejudicial to the public interest, then it may apply to the tribunal. So there are various things, okay, various differences of opinion when shareholder can apply, when shareholder may not apply. So failure to declare the dividend may not give the right to the shareholder to go for the operation and mismanagement. So if a shareholder who is also director of the company cannot claim the compensation under this particular provision by filing an application in the tribunal. But if the shareholder has died, whether his legal heir can go, yes, definitely they will have right to go under this particular section. Now section 241 talks about application to tribunal for relief in case of operation and mismanagement. But the rights to whom, when a shareholder can go, can a single shareholder go and apply under the operation and mismanagement? The answer is no. Okay, so for that matter we need to refer to section number 244 to understand in a better way. So let's try to understand right to apply under section 241. Right to apply under, we can use the short form, under section 241, under section 241. So who are authorized to apply? Okay, which shareholders are authorized to apply, which is given under section 244. Okay, so this section is linked with the section number 241, and it provides the eligibility of the members who hold the right to file an application under section number 241 for the operation and mismanagement. So that it is a kind of qualification criteria to go and approach the tribunal for filing the petition of operation and mismanagement. So who are the members who can go and apply under this particular section? So members having right to apply, which talks about that. So in case of a company having share capital not less than 100 members of the company, or not less than 1/10 of the total number of members, whichever is less, or any member or members holding not less than 1/10 of the issued share capital of the company. And if the company is not having the share capital, if it is a guarantee company, then not less than 1/5 of the total number of members. So we can say that this particular section with the diagrammatic representation, we can understand who will have right to file. So this particular section will give right to file to two class of shareholders, like company having share capital, and second category is company not having share capital. So that may be a company, guarantee company, which is not having a share capital. So under this also again we will have two further categories. Whichever is less of, so we can say whichever is less of, and here at least 1/5 of the total number of members. I can put a box to this particular provision. Okay, so here it talks about whichever is less. Okay, again there are two subcategories. least 100 members, at least 100 members, or at least 1/10 of total members or any member holding 1/10 of issued share capital. So where there are or any member holding 1/10 of issued share capital. Okay, so at least, so I can put just or condition over here. At least 100 members can come together and can file a suit or petition under this section, or 1/10 of the total members. Okay, so 1/10 of the whichever is less, okay, is the criteria given over here. Okay, so 1/10, if it is coming to the 10 number, then 10 may go and file a suit petition. If 100, then whichever is less, that number should be there for that matter. So any member holding 1/10 of the issued share capital will also get right to file under operation and mismanagement. So here under subsection 2, okay, which is given, any one or more of them having obtained the consent in writing of the rest may make an application on behalf of the all of them. So even one member, if he has received the consent from the other members, he may go to the tribunal and can file the complaint, file the petition application on behalf of the other members. So here we have completed 2 sections. So you may please write it down, these points. So we have started with Foss versus Harbottle, the rule of majority. These are the exceptions to the rule of Foss versus Harbottle under Indian law. We have started with section number 241 over here. We are going to study these 5 sections. So application can be made by member or the central government. Suo motu application can be made. Right to apply under section 241. The provision is given under section 244. Let's proceed, and we'll now try to understand powers of the tribunal. Powers of tribunal. Now the court intervention will be there in the matter. Okay, the powers of tribunal are given under section 242. Okay, so order can be passed by the tribunal. So if on the application made by the member or the central government under section 241, the tribunal is of the opinion, and if it is satisfied that the company's affairs have been or being conducted in the manner prejudicial in the interest of the public interest or the oppressive in the interest of the members, then in that particular case, and that the winding up of the company would unfairly prejudice such members, but that otherwise the facts would justify the making of the winding up order on the ground that it was just and equitable, then the winding up order can also be given by the tribunal. So the first point talks about the order passed by the tribunal. Order passed by tribunal on application made under section 241, okay, which we have already seen. Now, which types of orders, what will be the nature of the order which can be passed by the tribunal? So, nature of orders that can be passed. Nature of order that can be passed. Okay. So, which types of order can be passed? So, you can say an order may provide for the regulation of conduct company the purchase of shares or interest of any member by other member restriction on the transfer or allotment of shares termination aside agreements transfer, delivery of goods, property, manager, MD or director, recovery of undue gains made by manager, MD or director, or you can say appointment, directors, imposition of cost. Okay. So order relating to all these matters can be passed okay by the tribunal. So the order may provide for all these matters: the regulation of the conduct of the affairs of the company, purchase of shares or interest of any member by the other member relating to that, restriction on transfer or allotment of the shares, termination, setting aside, modification of any agreements, the setting aside of any transfer, delivery of goods, execution of other act relating to the property if it is happening in case of insolvency or other, you can say fraudulent preference, removal of manager, managing director or director, recovery of undue gains made by this manager, managing director or director, appointment of such number of persons as directors, and imposition of cost. So all these orders can be passed by the tribunal. After passing the order, the filing of the copy of the tribunal will take place. Filing copy of order of tribunal, within 30 days with ROC. So interim orders can also be passed. Alteration through order of tribunal. Okay, interim orders can be passed. There can be interim orders as well. Then alterations may happen. Alteration through order of tribunal. So whenever the order of tribunal makes any kind of alteration in the memorandum of articles, okay, So if any permitted in the order, then it will be consider that that is done. That can be done. So you can say that I can just put MOA, AOA. So company may not have power except to the extent if any permitted by the order to make any kind of alterations under MOA and AOA. And there can be punishment in case of contravention. Punishment in case of contravention. So if the company contravenes the provisions of, that is not amending the memorandum of articles, okay, so if company has not done it, the company shall be punishable with fine which shall not be less than 1 lakh to 25 lakh. So what will be the punishment? Company rupees 1 lakh. So it is fine to 25 lakhs, and every officer who is in default, okay, every officer who is in default, okay, can be imprisonment up to 6 months or with fine up to 6 months or with fine 25,000 to rupees 1 lakh. So these particular, okay, punishments can be there. So after making the alterations in the memorandum and articles, in all respect have the same effect as if they had been made by the company in accordance with the provisions of the Act. The certified copy of the altered order shall be filed with the registrar within 30 days. So this is section number 242. So we have seen powers of the tribunal. Order can be passed on application made under section 241. We have understood the nature of orders that can be passed by the tribunal, and then the procedures. Consequences of termination or modification of certain agreements which are defined under section 243. So if the tribunal has given any order relating to the termination or modification of the certain agreements, okay, then these provisions can be applied to it. So where an order has been made under section 242 for terminating, setting aside or modifying any agreement, then such order shall not give rise to any claims whatsoever. Okay, so no claim will be there, okay, against the company by any person pursuant to the agreement. So what you can say? No claim against company by any person for damages pursuant to such agreements. No manager, the other director or MD, no MD, manager or director, okay, be appointed for 5 years from the date of order. And in case of the any person knowingly doing it, then there will be a penalty, imprisonment for a term of 6 months or with fine which may extend to 5 lakhs. There can be penalty imprisonment up to 6 months or fine up to rupees 5 lakhs. So every officer in default. So MD, manager, basically who are the officer in default in this case, or director. So there can be penalty for that. Okay. So 244 we have already done. So these are the consequences of termination or modification of certain agreements. What will happen to the agreements, for which the order has been given by the court or tribunal. Then class action, that is the last part. Class action. Section 245. So class action, basically members and depositors or other individual members, they can file a petition for the reliefs if they are of the opinion that affairs of the company are being managed or conducted in the manner prejudicial to the interest of company and its members or depositors. So this particular provision provides that filing of application before tribunal on behalf of member. So first of all, this provision provides that filing of application before tribunal on behalf of members or depositors. Okay, so such number of members or depositors or any class of them, they can come together. Okay, and if they are of the opinion that the management of the company are being conducted in the manner prejudicial to the interest of the depositors, members, they can file an application to the tribunal on behalf of them, to restrain the company from committing an act which is ultra virus, to restrain the company from committing the breach of any provisions of the memorandum or association, to declare a resolution altering the memorandum or articles as void, to restrain the company and its director from acting on such resolution, to restrain the company from doing an act which is contrary to the provisions of the act, to restrain the company from taking action contrary to the resolution passed by the member. So to stop some acts, which are ultra virus in nature, such type of class action suits can be filed. Even that to claim damages also, the class action suit can be filed, in the tribunal. So required number of members, to apply, required number of members to apply, the same the same limit as per section 244, similar limit as per section 244, which we have already studied. Over here, company having share capital whichever is less of, and company not having share capital. But the only condition that in case of the share capital, there is one condition which is given. The applicants has or have paid all calls. So this is the condition, they should have paid all calls, then only they can file an application. So once the application, tribunal shall give regard to the following. Once the in case of admission of the application, public notice will be served on admission of the application to all members, depositors. All the similar application prevalent in any jurisdiction will be consolidated. 2 class action applications shall not be allowed. The cost and expenses for class action shall be defrayed by the company. The order will be binding on the company and all its members, depositors and auditors. So all these provisions are given under the class action suit, which is one of the weapon in the hands of the members at large. So they can come together, and file an application for the class action. So here we have completed in a nutshell all the sections, section number 241 to 245. I hope you have understood all these sections very well. So you can just make a note of the last 2 sections. I think you have completed this. Yeah, this one. Class action 245. So this is basically on members, depositors. Order shall be binding. So here we have completed all the provisions of operation and mismanagement. So we started with force versus arbitral, rule of majority, then we understood the various provisions under the Indian law, that is operation and mismanagement 241 to 245. We started with 241, then the connected provision section number 244, followed by 242, section number 243, and then finally section number 245. I hope you understood all these provisions. Okay, thank you so much for watching this video. Do watch this video and read the notes. In the next session we will come up with a new topic, okay, of the Companies Act 2013. Till then, goodbye.